ratified, and it's been ratified since uh 2020, January 27th, 2020. So do you want me to just introduce myself or to and stop or just let and go to Wendy, or do you want me to go on?
So we'll stop there, and then after Wendy kind of lays down the framework, then we'll switch to you where you can kind of go more in depth with your
Okay.
work and just the background of what's going on. Does that sound good?
Yes, that's fine.
Okay.
Thanks for having us, by the
Oh,
way.
yeah, no, thank you. I was really grateful to have met Wendy the other week, and we had her as a guest in a space about victim blaming, and we talked quite a bit about the ERA, and it was just a fascinating discussion. And afterwards, I felt an opening. I felt like this was the right thing, and I'm kind of I would consider myself a peace activist, and I really felt like this is a strong step forward for peace. So I want to, invest in this as much as I can. So anyway, go ahead, Wendy.
Great. Thank you so much, Katrina, and everybody for being here. I know sometimes more people come, and that's wonderful because I think the last time we did this, I don't know how the word gets out, but people just kept coming on, and it was great fun, and we had a long conversation. So I don't want to repeat too much, but I do want to give a quick synopsis of where we've been. And I guess just by way of introduction, I'll say, my name is Wendy Murphy. I am, and what I describe myself as anyway, I think I wear many hats, but as a lawyer, I'm a law professor. I teach a critical legal studies style feminist seminar on violence against women, sexual violence in particular. It's called Sexual Violence and Law Reform. And I run the Women's and Children's Advocacy Project at New England Law Boston, where I've been teaching for about 22 years. Um, I teach my students how to change the law, not obey it. That's the core philosophy. And I also do impact litigation and always have. I started my career as a prosecutor, watched the legal system mistreat women, and was just blown away. And in a very organic sense, kind of became an activist because it was so horrifying to watch the legal system mistreat women and no one seemed to care. And I would object and tell judges they didn't have the authority to do that, and because they were discriminating against women, and they would roll their eyes. Anyway, when I left the DA's office, and I've been doing this for about 37 years, when I left the DA's office, I decided to become an activist because it seemed to me once I just called attention to these grave injustices, everybody would change the law and say thank you. Oh man. Anyway, uh, not a blink of an eye later, I landed on civil rights laws and constitutional laws as the primary problem in a lot of the issues that I was seeing. In other words, I pretty quickly abandoned any commitment to legislative reforms because if you don't have equality at the baseline, it doesn't matter what laws you change. It doesn't matter um, what the legislature does, so long as the other branches of government have the authority to enforce laws unequally on behalf of women. Why would you waste your time? I mean, every single law on the books, no matter what it says, can be applied unequally to women. So, why would you waste your time fixing laws when you need to be fixing the Constitution? It was so obvious to me, and yet it has been a monumentally difficult task getting people to consciousness, number one, but then agreeing to unite in the fight, because frankly most major women's groups are not just co-opted or corrupt, they are intentionally designed to distract women from paying attention to the primary cause of their suffering, which is this constitutionally mandated subjugation. So I think one of the good things about my career is that it did literally force me to start framing all of my work through a constitutional lens a very long time ago. And then eventually, and I'll explain what I mean, eventually the Equal Rights Amendment became uh, viable again. And what I mean by that is there became an opportunity to actually fix the Constitution, which wasn't something I was even thinking of, when I started doing activism in the early 90s. So I quickly shifted my focus to the fight for the ERA and became involved, especially with Equal Means Equal, long before the states started ratifying more recently. Um, and then, so, however many years ago that was, it has become a real labor of love, only in the sense that win or lose, what I've learned is that it's really important to know who your friends are and to not spend time and energy on people who aren't your friends, because they're just not going to help, and they will drag you down and distract you. So now I want to go back to the basics and just, where we began in this country with the issue, and how we got to where we are, and some of the tougher lessons learned along the way, both in terms of who understanding who your friends are, but also how do you get things done. And I think we've learned a lot in this battle for the ERA about how not to get things done. And we're getting a little closer to the answer to the question, how do we get things done? So let's go back to when it all began. I mean, the real crux of the problem, I guess, starts in the 1700s, when we were first a nation, physically first a nation of people attempting to create a country. We were colonized by England, and that brought with that colonizers brought with them the so-called British common law, English common law. And under the English common law, women were nothing. They didn't exist. They were property of their fathers and husbands. And that was just an accepted principle of law when we were just developing and beginning to think about what kind of government we would create and how the laws would work in this country. And when we finally became a country and adopted our own constitution, which took effect in 1789, it wasn't explicit that women weren't equal, but there was a lot of language that suggested women weren't even, they just didn't exist. And that include things like in the Declaration of Independence, the language, um, all men are created equal. You could argue that they didn't mean men versus women, they meant people. But the reality is that really was intentional, and it kept shining through that that was intentional. So flash ahead to after we adopt the Constitution in its basic form, there was already a plan to add a Bill of Rights, because the original version was just how to structure the government, and then of course they wanted people to have rights, and the Bill of Rights gets created, and it doesn't say men have rights and women don't, but it doesn't say anything about women. It doesn't say anything about men either, except again in this sort of passive generic language. But um, it was clear that this was a country that treated women and expected women to accept this as stuff, as the property of their husbands and fathers. And that really was how things were carried out as well. When women tried to assert themselves or buy property and so forth, they often couldn't. They couldn't assert themselves. They couldn't vote. They couldn't exercise basic rights, even though the law maybe didn't say that they couldn't. They were learning by being denied that they had nothing. And then of course, states passed their own. Eventually, states passed their own constitutions, and many of them did give women rights. And there were all sorts of things happening in the states to give women rights, fully aware that this was different than what the federal government had given women, which was nothing. So women had rights, but it really depended on the state, and it also depended on what rights the state gave you, and they were often very limited. Um, so women started to rise up. Of course, there was a huge fight, as you all know, in the 1800s about slavery. Women and Black people were working together in the fight against slavery, and the debate, there wasn't really much of a debate between Black people and women as to who deserved rights. They were both kind of on the same page that, of course, this was a united front. But then there became a divide, and of course, that divide was forced upon Black people and women to take away some of their power. Their united power had to be divided to weaken it, and it was fairly successful. There were some unfortunate moments in that battle that it eventually did pitch women against Black people, and some of the scars of that are still around today. But the reality is, it wasn't of their own doing. It really wasn't. It was powers external to women and Black people that separated them, and we don't talk enough about that. Even Frederick Douglass early on was very supportive of women's rights, women's equality, women getting the vote. Um, but when push came to shove and our Constitution was amended after the Civil War in the so-called Reconstruction Amendments, 13th, 14th, and 15th, the 13th abolished slavery, the 14th created due process and equal protection rights, um, and the 15th gave Black men voting rights. The 14th gave white men voting rights. Uh, but it was really around those Reconstruction amendments that we really see the beginning of the problem for women in written form. And what I mean by that is the 14th Amendment in particular said white men have the right to vote. And that was the first time the word man appears in the Constitution in that direct manner. Like, we are only giving rights to men, and white men at that. Well, in that very same amendment, the 14th Amendment, another provision gave persons due process rights, very, very important due process rights, and also equal protection of the laws. Now, women had been fighting for these kinds of basic rights for many years before the 14th Amendment was adopted in 1868. In fact, many of you probably know the story about uh, what happened in Seneca Falls in 1848, the Declaration of Sentiments, which was sort of similar in tone and style to the Declaration of Independence, only it said all men and women are equal under the law. And there was a lot in that document that made clear women were quite aware that they had nothing and that they needed to have rights. So the fight and the move toward the Reconstruction amendments was really a fight for the right not just to free Black slaves, but also to liberate women from their status as nothingness. They had nothing. They were not persons, and they wanted to be elevated to at least personhood. And they sort of thought they got that in the 14th Amendment, because that amendment said all persons shall have equal protection of the laws. Well, if you were a human being and you thought you were a person, and even if you were a woman, you'd say, well, that's terrific. Women are persons. So, of course, we have equal protection of the laws. Women started filing lawsuits demanding enforcement of their equal protection rights. And there were a couple of famous cases where they did that right out of the box after the 14th Amendment was adopted. And they lost. The court didn't even one of the women in one of the more famous cases, a woman sued under the Equal Protection Clause, saying she was being denied equal protection rights when she was forbidden to vote. And the court didn't even address her equal protection argument. They just said, no, we're just not even going to answer the question. Do you have an equal protection right to vote under the Constitution, even though we have given that right to white men and Black men, and you think you're equal under the law because of the 14th Amendment? Well, we're not even going to indulge your argument. So, over the course of time, women learned that the Supreme Court did not see women as persons. The 14th Amendment gave equality to persons, but not to women. And then the court kept deciding cases where they would say who persons were. And they covered categories like race and national origin. And hell, they even covered corporations. There's a late 1800s case where corporations fight for equal protection of the laws, and the court says, okay. So corporations had equal protection of the laws in the 1800s. Women did not. Women immediately then, we're going to need our own constitutional amendments. And they started very fiercely asking for only two things. One, the vote, and they knew they had to get the vote first. And then once they got the vote, they were going to move to equality. They knew those were the two things they didn't have that would guarantee them all the rights they needed, and would and that equal protection of the laws would cover all the other laws. So it was really all they needed was the vote, and then equality. Equality would modify their rights under all other laws and all other government actions. So they fought for the vote for a long time. It was more than 50 years between the time they first filed a suffrage amendment to give women the vote. They didn't get it until 1920. And then, importantly, I'll just say as a footnote, the primary reason women won the right to vote in 1920 was because Alice Paul got involved and she formed the National Woman's Party in 1916. Women had been fighting for decades for the vote and it was going nowhere. I mean, there were things happening, don't get me wrong, but when Alice created a nonpartisan woman's party, that's when things went crazy, because by forming the National Women's Party, she was saying to both sides, don't you tell us what you're going to do for women. We'll tell you what you're going to do for us. You're going to support suffrage. We are a one-trick pony. We don't care about any other issues. Don't tell us about abortion, pregnant. Don't tell us about anything. We want the vote, and you're going to give us the vote. And if you don't, we're going to run you out of town and make sure you don't win. And they said that to both sides. Their fierce, nonpartisan nature is what enabled them to win. And they did. A few years after the Women's Party was formed, and because they were nonpartisan, they won the right to vote in 1920. We probably would have won it eventually, but they won it then because of that brilliant strategy. Alice Paul was brilliant. If you don't know much about her, do a little research. She had multiple advanced degrees, a PhD from Penn. She was a political genius, which, by the way, is why she had to be marginalized. And she also had to watch the Women's Party be destroyed. And it was destroyed internally by, people who pretended to care about the issue became part of the leadership and just sucked the life out of it and destroyed it. Most people don't realize this, but the National Women's Party's dissolution became final in January of 2021, and nobody even paid attention. There was no news story, there was nothing, because the erasure of the National Women's Party and the invisibility of it was important to destroy the power of women uniting as a nonpartisan, unbelievably powerful front. The party itself had to be destroyed, and it was. And now, it just has no value whatsoever, except as a memoriam of some crazy sort. It's like a museum for women's rights, as if we no longer need to have them because now we can just have a museum about them. I mean, whoever created that place should be slapped. It just makes me sick that the National Women's Party was killed, and we now have a museum. Oh my God. Anyway, don't let me get distracted. So after we won the right to vote, Alice Paul immediately turned her attention to the ERA, and a couple of years later, in 1923, it was filed with Congress for the first time. The language of it was changed a little bit in, I think, 1943. And it's unfortunate that it was changed, because the original language of the ERA in 1923 said men and women shall have equal rights. And that was important. The language men and women was important because Alice was trying to fix the thing that was broken. And the thing that was broken was the inclusion of the word men, in the 14th Amendment. And if you're going to give men certain rights in the 14th Amendment, and now you want to fix the Constitution by adding an amendment to repair the use of the word men, you got to use the word women. And Alice knew that, and that's why that language was in the first version in 1923. But for reasons that I find unfortunate, but I understand, it was changed in 1943 to what it is now, which states equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. So you can see they took out the word woman, used the word sex as a substitute, which it instantly was problematic, because it now was implying that the Constitution needed fixing for men too, which of course it didn't. It just watered down the nature of the problem. Having said that, they did it because it mirrored the language used in the suffrage amendment. The suffrage amendment says something similar about the right to vote, shall not be denied on the basis of sex. So they were trying to just keep consistent with that amendment. And I think for practical reasons and perhaps for political reasons, Alice was persuaded that this was the right way to go. But I don't think she actually appreciated that kind of change. Nevertheless, it gets rewritten in 43 and a whole lot of nothing happens. Neither party supports it. It just doesn't get any play. No one's talking about it. There were little blips along the way. There were a few little moments when it got a little bit of attention, but it didn't really go anywhere until the civil rights era. The 60s, the Women's Party and Alice Paul were on fire, and women were on fire with the civil rights movement. They were part of the civil rights movement. I hate to call it the women's movement because that suggests that they were separate from the civil rights movement. But women's rights are civil rights too. And when I hear people say women's rights and civil rights, I get nervous because I think, well, why aren't women's rights civil rights? Why are you separating them out? Why are you segregating women from the nature of civil rights? Because that language, civil rights, is so powerful. Why take that away from women and suggest that they have something, number one, that's separate, and number two, that isn't civil rights at all? It's something other, something less than. So I sometimes do use it because colloquially it's important, I think, when you're talking about the fight and where we've been. But the point is that the National Women's Party was on fire in the 60s. They were moving like lightning speed toward Congress with the ERA in terms of making Congress feel like they really had to do it. This was the time they had to pass the ERA. Um, and it was getting a lot of support from both parties. I think most people don't realize this, but the Republicans were quite supportive of the ERA at that time. The Democrats were too, but it really was a very strange moment in time when, as it should have been, and because of Alice Paul's nonpartisan fierceness, both parties were wanted the women's vote. They were courting the women's vote, and no one wanted to appear anti-ERA. So they were all over. They were all over Alice. They were all over the Women's Party, and they were all over the ERA. And as it got closer and closer to coming to a vote, there were obvious efforts underway by both sides to find a way out, to find a way to resist without appearing to be anti-women. And if you read some of the Senate debates, some of the House debates, you can just see how they get all lost in silliness about why it's not a good thing. Oh, gay people will get married and all this stupid stuff about why the ERA would be bad for humanity. It doesn't matter because what ended up happening is really two important things happened that are both of which were terrible. One is that the National Organization for Women's they were created in 1966, and their president at their first national convention announced that they would not be supporting the ERA. This was devastating. It was devastating. Alice was furious. She was just so angry. Now, mind you, women were so supportive of the ERA. They put a lot of heat on Now, and Now did come to the table, and they did in fact testify in support of the ERA once it got close to passage. They were in support of it. But again, if you read the congressional record, it's very clear that it was Alice Paul and the Women's Party that got it to where it got to. And Now was sort of a passing supporter, but but they were on board now, ready to do the right thing. Here's the problem. Both parties, both parties.
Hey, Wendy,
Yep.
I'm gonna, I think someone's mic is on and I hear lots of feedback. Can each of the speakers make sure that they're muted
Yeah,
over there?
I hear some noise too. Yeah.
Okay.
Okay,
Okay.
thank you. Thank you, Katrina. So, what happened, we were really very close to getting the ERA done, and then out of nowhere, women's groups supported the addition of a deadline. What I mean by that is women's groups supported a deadline that would say to the states that had to ratify this amendment if Congress passed it. Now, then the states had to ratify, right? For people who don't know, an amendment can only become law if two things happen. Congress has to pass it, and then it has to be ratified by 3/4 of the states. 2/3 of Congress have to ratify it, have to propose it, and 3/4 of the states have to ratify. Well, Congress decided at the very last minute, and I say this because from the moment the ERA was first filed until 1972, it had no deadline, and that was intentional. I mean, it took women decades to get the vote. They certainly weren't going to get equality in 7 years, and that's the deadline that Congress imposed, a 7-year deadline. Alice Paul was sobbing outside of Congress at the time the deadline was added. She was sobbing on the day the ERA passed, and it was not tears of joy. She was sobbing because she knew the deadline would ensure the ERA's defeat, that we would never get it done in 7 years. And she was right. And that's how bright she was. She knew that it would be easy to just get the number of states they needed to prevent 38 states from ratifying was going to be easy. So the ERA passes Congress with the deadline. It gets sent to the states for ratification, and there's not a lot going on in terms of persuading the states to ratify. Women were not organized. There was not a lot of attention being paid to getting the states on board until it was too late. So I should be clear about this. Many states ratified quickly, and then things stopped. They really stopped quite abruptly, and they stopped for the most part in 1973. Now, I want to say this because it's really important, even though it's a little dense, but I want everyone to know this because it matters right now, and it really matters to what's going on with abortion and this election. In 1973, two important cases were decided. One, Roe versus Wade, and one, Frontiero versus Richardson. They were both decided uh, in the summer of 73, roughly within a couple months of each other. Um, and they ended up completely undermining the ERA. I want you to remember that Roe versus Wade undermined the ERA. Here's why. The whole point of the ERA was to give women the same quality of rights as everybody else. When Roe versus Wade was decided, the Supreme Court, in its written words, gave women equality of rights at the highest level for abortion. And then in the Frontiero versus Richardson case, again, also decided in 73, the Supreme Court gave women full equality of rights under the 14th Amendment. So we didn't just get personhood, we got personhood at the top tier. I mean, this was incredible that we had everything we could have dreamed of that we had ever been fighting for came to us in 1973. And why that killed the ERA is simple. Women could not then persuade states to ratify. It became an irrelevant, moot issue. The states all said, we don't have to ratify. The Supreme Court just ruled in your favor. On abortion, you've got maximum legal protections, strict scrutiny. And on equal protection rights under the 14th Amendment, you got strict scrutiny, maximum legal protection. What are you complaining about? What more do you want? And women could not say anything because they weren't missing anything. Not as of 1973. No surprise, very few states ratified after that. All the air came out of the ERA's balloon. So why is this important? Because as soon as it was clear that the ERA would not be ratified within 7 years, even though the 7-year period was then extended to 10, so we got a couple more years out of Congress. But as soon as it became clear that the ERA would not be ratified by the right number of states, we made it to 35. We needed to get 3 more. When it became clear we would not get those 3 states, that's when the Supreme Court overturned Frontero versus Richardson and took our full equality under the 14th Amendment away. They took it away. They took it away, and Justice Rehnquist, in a dissenting opinion, explained how delighted he was that at least he didn't like the opinion at all because it gave women some degree of equal protection rights, but it really bumped them down to very weak protections, not full equality, but second class equality. And Rehnquist said, well, I don't really think women deserve even second class equality. They should be even lower than that. But at least they're not at the top tier anymore. I mean, he wrote that in his dissent. He was a monster, but he literally said, "Oh, at least the good thing, the only redeeming thing about this ruling is that it bumps women down from full equality to second class equality." That's all because of Roe versus Wade and Frontero versus Richardson. But the other thing about Roe versus Wade that matters is it created abortion as a separate issue that, according to the Supreme Court, had nothing to do with equality. Now, of course, that's dumb, wrong, asinine, stupid, irrational. I mean, how many words do I need? Of course, abortion is all about equality, but the Supreme Court just separated it out, gave it its own little body of law, said it had something to do with a penumbra and privacy, but not equality. Nothing in there about equality. And what this did, which also helped kill the ERA, is it divided women's resources. All of a sudden, because we had Roe versus Wade to deal with, we also knew this was a brand new doctrine of law. We now had to run around the country fighting, spending our money on lawsuits to help establish what Roe versus Wade would mean for women in the trenches. What does it mean? What do the words mean? What does strict scrutiny mean? What does penumbra mean? What does trimester mean? There was so much litigation and so much importance placed on abortion, but it was separated from equality. So all the resources and energy, politically and otherwise, that should have been focused solely on equality got divided. Equality was over here, abortion was over there. Our resources got divided. It's always about divide and conquer, always, politically anyway. So the deadline comes in 1982, and we did not reach 38 states. We needed 38 for the ERA to become law. The day came and went, and we only reached 35, and a lot of women gave up. And women gave up because they thought, well, the deadline expired. There's nothing else we can do. And they were tired. We don't want to go do anything else. We're exhausted. We've been fighting for this for a long time. Some people didn't give up because some people were pissed off enough about the deadline, and then something wonderful happened in 1992. So this is 10 years later. 82, the deadline expires. 92, something wonderful happens. The 27th Amendment was adopted by this country. We ratified the 27th Amendment. Here's why it was wonderful. The 27th Amendment, by the way, deals with the timing of congressional pay raises. I don't even know why it's in the Constitution, but it is. But it was adopted 203 years after it was proposed by Congress. It got 203 years to ratify. We got 10. Women were pissed. We were so pissed off. We started fighting back, and we said, wait a minute. You can't have a constitution where some amendments get 2 centuries and others get 10 years. It's not okay. So women at that time said, we are going to fight for 3 more states to ratify. We're not giving up. We're going to go win 3 more states. And then we're going to go to court and argue that the deadline is invalid because you can't do this to women. You can't give us 10 years and give that other amendment 200 years. It makes no sense. It makes the Constitution look stupid. And that's what we did. We started fighting. And then something really wonderful happened in 2012 that lit this issue right on fire. And that was the United States archivist publicly said, I will put the ERA in the Constitution if women get 3 more states to ratify. That's it. We were on fire. And we did everything you can imagine to get those 3 states to ratify, and led largely by equal means equal. Um, we got Nevada to ratify in 2017. We got Illinois to ratify in 2018, and we got Virginia to ratify in 2020. Well, before Virginia ratified, I had already been planning with Equal Means Equal to represent them in a lawsuit, because I knew, I mean, we all knew that once Virginia ratified, there would be lawsuits. Whether we filed them or the anti-ERA people filed them, we knew there would be lawsuits because people would complain, well, the deadline expired, et cetera, blah, blah, blah. So I was running around the country giving lectures about what my lawsuit would look like once Virginia ratified. And I was explaining to people why the deadline is not valid and why the Constitution doesn't allow the imposition of deadlines. And, I won't bore you with all of those arguments because they're important, but they're not as relevant. And I want to make sure everybody has a chance to speak. Um, we we were planning a litigation, not knowing exactly what it would entail. And lo and behold, exactly what we worried about did happen. So when Virginia finally got around to ratifying, we were already ready to file a lawsuit because we'd been planning it for years. Virginia finally ratifies in January of 2020. And we knew they were going to ratify at the end of January. We knew what their plan was because I'm sorry, yeah, Virginia. God, I'm mixing my brain up. Virginia, we knew Virginia was going to ratify in January, and we knew approximately when they were going to do it, and we were ready to file after January, whatever the date was, 27th. And then something weird happened, which is that anti-ERA states filed a lawsuit. I think it was in Tennessee, or was it Kentucky? Wherever it was, they filed a lawsuit in the South um, to prevent Virginia from ratifying, and really to prevent the archivist from publishing. But Virginia hadn't even ratified yet. So they really weren't suing Virginia, but they basically were saying it doesn't matter what Virginia does because we're suing the archivist to stop the archivist from publishing even if Virginia ratifies. And they did that in early January. They did that long before Virginia ratified because they wanted to get their foothold in a Southern court that, of course, would rule against women, they planned, in a state that was unfriendly to women and in a state that had not ratified. So I immediately filed our lawsuit in Massachusetts federal court. And I also didn't wait for Virginia to ratify because I didn't want to give them a head start. I did not want the antis to get the benefit of a head start in a southern state. I wanted some state like Massachusetts in the north to have a chance to rule. Because I thought this was going to be a fight between the North and the South. Oh, was I wrong? But I filed my lawsuit also against the archivist, and my lawsuit was to compel the archivist to file. We found out roughly around the time we filed that the archivist had reneged on his promise and would not be publishing the ERA when Virginia ratified, because the Department of Justice, the Office of Legal Counsel at the Department of Justice, then under Bill Barr, so Trump was in office, had written an opinion letter saying, we don't think the ERA should be published in the Constitution because of the deadline. Now, mind you, the Department of Justice, the Office of Legal Counsel, they don't have any power over the archivist. They have no authority whatsoever to tell the archivist what to do. And the archivist instead is mandated by federal law. It's very explicit law, 1106B, and it says the minute the last state ratifies, the archivist shall publish forthwith. That's it, shall publish forthwith, not, only if the Department of Justice says so. It's a mandate. You must publish. And we had reached that stage where it was mandatory. He had promised he was going to do it, and he reneged. One of the interesting things that happened at that time was that he basically didn't disagree with us that the Department of Justice couldn't tell him what to do. But at that time, he said, I'm going to wait to hear from the courts. I'm not going to publish until somebody resolves this in the courts. And we were in the courts. So we were hopeful that our case was going to give the archivist authority to do what he knew he should be doing. But frankly, what he should have done at that time was to say to the Department of Justice, "Nice try. You're not my boss. You can't tell me what to do. I'm mandated. I'm going to follow the law. If you want to undo publication, sue me, but I'm going to do what the law says." He didn't do that, and that really was unfortunate. And yeah, more than unfortunate, because it put the burden on us. After I filed my lawsuit in Massachusetts federal court, another lawsuit was filed in DC federal court by the last 3 states to ratify that. My lawsuit was on behalf of women. The lawsuit in DC was on behalf of states' rights. Both of us made the same arguments. The ERA is valid. The right number of states have ratified. It's all set. We don't need anything else. You got to make the archivist publish, period. And there were a lot of scholars on our side, a lot of scholars. I'm not saying everybody was in agreement, but a lot of scholars, constitutional scholars, agreed with us. Trump's Department of Justice fought against us in both lawsuits, and women, and this was again 2020, so it was the presidential year. Women were urged to vote for Biden and Harris because they both said publicly during the campaign that they support the ERA. They talked about it. Women, of course, then immediately turned and turned around and strongly voted for Biden and Harris, as did I. And he got into office, and once he was sworn in January 2021, we all waited with bated breath for Biden to destroy that Department of Justice letter and stop fighting against us in our lawsuits. And the exact opposite happened. Biden did not rescind Trump's letter. In fact, it's still in place today. Biden issued his own letter to make himself sound a little bit better than Trump, but his letter blocks the ERA as well. Biden also kept fighting against my lawsuit, kept fighting against the lawsuit in DC, and made exactly the same arguments against the ERA that Trump had made. And women were horrified. We were disgusted, kind of shocked. I mean, I wasn't that shocked, but people were shocked. And we now had a problem on our hands. I mean, what we did have was at least the clarity now that neither party supports the ERA, which I already thought was the case anyway. Now we had this vivid clarity that neither party supports the ERA. So what are we going to do about it? In case you're interested in what happened to the lawsuits, both failed on procedural grounds, lack of standing. The archivist doesn't have to do this, and the DC appellate court, in fact, actually addressed the merits a little bit and said, Congress can put in a deadline if it wants to. But the DC Circuit Court of Appeals is notoriously conservative and by no means is the final word. We still don't have the final word from the Supreme Court of the United States. So courts around the country are free to apply the ERA if they want. It's valid right now, and it should be enforced. I filed a brief in Nevada not last week, but in the past couple of weeks, arguing that the ERA is valid and the ERA should be used to uphold, to strike down abortion restrictions, funding restrictions that Nevada has adopted, limiting women's access, limiting especially poor women's access to abortions in Nevada. And I wrote Nevada ratified the ERA in 2017. It should be part of this lawsuit. You should sue under the ERA when you're trying to protect abortion rights, because of course it affects equality. And unfortunately, the lawyers who sued on behalf of women in the Nevada abortion case last year, which was the ACLU, they filed their lawsuit and did not assert a claim under the ERA. So it's an interesting dilemma, isn't it? That Nevada, as a state, accepts that the ERA is valid, but the lawyers who filed the abortion case in Nevada, claiming to be speaking on behalf of women, and who know that Nevada ratified it and believes that it's valid, like most states, did not assert a federal ERA claim, even though the federal ERA gives women maximum protection for all their rights, including abortion rights. So you figure that one out. And not only that, I'm trying to intervene in the case, and I learned this week that the ACLU and the group that's suing, which is an abortion provider, is opposing our efforts to intervene. And my intervention motion just seeks to help them by advancing a claim under the ERA, and they're opposing intervention. I mean, just this is where we are at this time. The idea that people are out there fighting for abortion rights who are also hostile to women's equality. So even if they win in Nevada, if they win without an ERA claim, they might win the case and they might win, protection for women, and they might strike down those abortion restrictions, but they will be making bad law for women when doing that, because they will not have done what they should have done, which is to advance the strongest possible arguments for women. And the strongest possible argument for women is always the federal ERA. Now, mind you, there is a state ERA claim in that case, but a state ERA is only as good as its federal roots. Because if you have a state constitutional ERA and the federal ERA doesn't exist yet, state courts and state government officials are free to interpret the state constitutional ERA in a way that treats women as second-class citizens. Why? Because it's allowed under the federal Constitution. As long as the federal Constitution permits sex discrimination, even state constitutions can be discriminatory, even when they have language in their constitutions that state that women are equal. Equal does not mean equal unless the federal Constitution says so. So that's where we are with a lot of these abortion cases, not just in Nevada, but in other states. No one is filing ERA claims, federal or otherwise. A couple of states, there are claims under state ERAs, but it doesn't matter. And even in the claims where they're arguing state ERA protections for abortion, they're not asking for maximum legal protection. They're asking for second-class treatment, second-class enforcement. It's outrageous what's going on in these state abortion cases. Meanwhile, they're being used politically to persuade us to vote for Democrats. This is why I want to bounce back to what I said to you. Think about how abortion killed the ERA. And now here we are again. The ERA is right back up here front and center as an issue. And abortion is again being used, not so much to kill the ERA, but to distract us from focusing on it as the only thing that matters. So by the way, just to go back to the lawsuits, the one I filed, the one in DC, were both unsuccessful on procedural grounds, and otherwise they failed. And we both had judges that were as liberal as you could expect in federal court. I had a Black female Obama nominee judge in federal court in Massachusetts. The judge in DC was a Puerto Rican Obama nominee, and we both lost brutally. I mean, the judge in the DC case was especially brutal. Mine was just kind of an idiot, but she ruled against us. And this is just more of what I've been saying about how this is not a left-right issue. It never has been. If this were a left-right issue, both of those judges would have jumped at the chance to use their positions as federal judges to validate the ERA, because there's plenty of scholarly support for that view, and yet they didn't. And then Biden came along with the chance to help, and he didn't. He did exactly the same thing that Trump did. Exactly the same thing to block the ERA, made exactly the same arguments against the ERA. So we're left now in this position where, although I'm running around the country filing briefs in these abortion cases to shine a light on the duplicity of these abortion groups that are claiming to be fighting for women's rights, when all they're really doing is arguing abortion cases in a context where they're asking the courts for second class treatment of women under the Constitution, which to me is malpractice. You should not be allowed to claim that you represent women as a class in a lawsuit and ask for second class treatment. But that's what they're doing. And that is malpractice against me. So I'm running around the country intervening in these cases, accusing them of malpractice, because somebody has to. It's outrageous, absolutely outrageous. And these politicians think we're stupid and we're just going to vote for Democrats because of abortion. 2% of women in any given year need abortions. 100% of women, including women who need abortions, need equality under all laws, including abortion laws, 24/7. So why are we voting? Why are women supposed to vote in a national election about something that affects only 2% of women a year when equality is also on the table and affects all women, 170 million women all the time? So I just want to end by saying, because I think the most important thing you're going to hear from Arlene when she speaks is that we're now in this wonderful position to be able to pressure Biden to do the right thing because he needs the woman's vote. He's going to lose. He's going to lose, and he needs the woman's vote. And that gives us enormous leverage. If we unite and say, we will not vote for you unless you do this, he'll do it. And if we don't, he won't. I mean, it's really that simple. It is really that simple. And we only have that leverage between now and November. That's why we're speaking tonight about the importance of unifying around this issue and using this moment in time. And don't, please, let's not talk about how, well, if we do that, Trump will win and aren't you a horrible human being? No, if women don't vote for Biden, because he refuses to unblock the ERA. And as a result, he loses the election. That's on him. That's not on us. That's not on me. That's on him. So I don't ever get sucked into that argument, ever. This is our moment in time. This is our leverage, and it's either going to be now or never. If he does it, then women will vote for him in droves, and if he doesn't, they won't. That's my view, and we have to get the word out and make this point over and over and over again. So I just want to say, though, before Arlene speaks, to make the point as crystal clear as I can, because it's a little bit funky, the legal question of, well, what do you mean women don't have equality? Do we? Don't we? Where are we in the 14th Amendment? Women didn't become persons under the 14th Amendment until 1971. That was the first case, Reed versus Reed, where the court basically said, fine, women can be persons. And it was after that that women suddenly could sit on juries in every state and they could suddenly get credit in their own name. And that's when all this stuff started happening. People talk about the 70s like it was a great, like women started fighting for their rights all of a sudden. No, literally, we got into the Constitution in 1971, which made it suddenly illegal not to let women get credit cards in their own name. And that, it was illegal not to let them sit on juries. States allowed women to get credit cards and states allowed women to sit on juries, but it wasn't a mandate. It wasn't required. It wasn't required. So what we're talking about is requiring the equal treatment of women, not hoping the states sometimes do. And this is what Scalia said in 2011 that people need to remember. And thank God he said it, because he clarified the point for a lot of people because they listened to him. He said, it's not that the Constitution requires discrimination against women. I'm sorry, am I saying this the wrong way? It's not that the Constitution requires discrimination against women. It's whether it prohibits it. It doesn't. And he's right. And he said it out loud. And it was a really important moment because it now is kind of crystallized for everyone who wonders what the hell women's status is. That's it. It's not mandatory that the government discriminates against us, but they can. They can, which means all the laws, all the government actions, every regulation, every government policy can be applied differently and worse when applied to a woman. It can be enforced differently and worse when applied to a woman. This means even if we pass equal pay laws, and an equal pay law could, that says women must be paid equally to men, and then you don't get paid equally, and you go to court and you say, I'm not getting paid equally, and this law says that I'm entitled to equal pay, guess what the judge could say? Well, I realize that you're not getting equal pay, and I realize the law says you're entitled to equal pay, but because you're not entitled to constitutionally equal treatment under any laws, including equal pay laws, I, as the judge, can interpret that equal pay law in a way that allows that company to pay you less than a man. So this is what we're dealing with. This is how simple and basic it is. You can pass an equal pay law and still receive unequal pay, which we do today. It's 82 cents on the dollar. And that, that margin is the difference. That's sort of the legal difference between full equality and where we are now. We're bumped down to 82% of personhood. And then therefore we get 82 cents on the dollar. It's a way to think about it anyway. And so without the ERA, it means all laws, all rules, all regulations, all government policies, all government officials, state and federal, all branches of government, legislative, judicial, executive, all of them, police, prosecutors, judges, everyone has the constitutional authority to treat women differently and worse simply because they're female. This is why Title IX sucks compared to Title VI, even though they are exactly the same language. Title IX reads exactly the same as Title VI, but Title IX on campus is treated like shit, and Title VI is treated as the gold standard civil rights law. Why can they do that? Because the Constitution doesn't require equal treatment of women, much less their sex-based suffering. Why do we have high rates of rape, domestic violence, stalking, femicide? Because women aren't entitled to equal protection of the laws against rape, domestic violence, stalking, and femicide, or I should say homicide. We have a thing called femicide because women aren't entitled to equal protection against homicide. This is how it works. You can stick in any law you want. Why do women lose custody of their children in family court? Because family court judges aren't required to treat them equally under divorce and custody laws. I mean, research is overwhelming that women in every state in this country in family court suffer biased treatment by the courts. This is what the research shows. And nobody's asking why. The why is because we don't have the ERA. It's really simple. It's really very simple. So that's all I want to say, even though I could talk for 4 hours straight. And I'm going to turn it over now to Arlene to talk to you a little bit more about why it is that Biden has both, in my view, the moral and legal obligation to get the publication done, to get the archivist to publish the ERA, but also what other aspects of the law really do compel him to do the right thing. Go right ahead, Arlene.
Thank you, Wendy. I always learn more things from you every time you speak. Um, okay. I started working on this, and my sister's on here too. Her name is Gina Colias, and she is a lawyer also. And we worked together with another attorney on the amicus brief for 86 friends of the court in the lawsuit Wendy filed back in 2020. And as she said, that lawsuit was dismissed for lack of standing. And lack of standing means to file a lawsuit and be able to pursue your lawsuit, you have to have an injury. So, in other words, the law has to hurt you in some way. And so basically the courts were saying that just because the archivist refused to publish the ERA, that it did not hurt women, which is absolutely ludicrous. So, but that's what they held, and they threw the lawsuit out. Okay. And then the other thing I'll tell you this now, but right after Dobbs came down, the three states lawsuit was still going on, and it went on until around February or March of 2023. So Biden had been in the White House for 2 years, over 2 years, and he allowed his Department of Justice to fight against publishing the ERA for over 2 years. And after Dobbs came out, which was in June of 2022, that a few months later they had an argument in the DC Circuit Court of Appeals, the oral argument. And what the government argued was that the states did not have an injury, the three states that had just ratified it, the last three states, because they agreed that either on one hand, if the deadline, the 7-year deadline, which I'm going to talk a little bit more specifically about that in a minute, if the 7-year deadline that was turned into 10 years was legitimate, then the ERA was not the 28th Amendment to the Constitution. But if the deadline was void, which it is void legally, and I'll tell you why in a minute. If it was void, then the ERA was already the 28th Amendment, whether it's published or not, and that's based on a 100-year-old case from the Supreme Court that says because of what the Constitution says in Article 5, which is the one that tells Congress and the country how you can create amendments to the Constitution. It says that as soon as it's ratified by 3/4 of the states, that it shall become an amendment. So the Supreme Court ruled that the minute the last state ratifies, it becomes that amendment. So they said that it either is an amendment or it's not an amendment, but regardless, the states don't have a dog in this fight because they can't change that. It's either is or it isn't. So the court dismissed the lawsuit for lack of standing. So, so let me just tell you that it is very important why the 7-year deadline is not valid. And there's a lawyer in Chicago named Michelle Thorne, and she did a wonderful thing. It was published in May in the Chicago Bar Record, which is like the Chicago Bar's Journal where they publish legal things. And she did an analysis of the idea of the deadline, which was in the resolving clause of the ERA. When Congress proposes an amendment, it creates a resolution, just like any kind of organization would have a resolution, and they'll say, "Be it hereby resolved that blah blah blah, and because of blah blah blah, then we hereby," and then it puts the resolution part, "We hereby resolve that blah blah blah." Okay, and at the bottom of an amendment resolution is the text of the amendment. So at the bottom of that resolution, it has just the text and it has 3 sections to it. And one section says that you can't discriminate against anyone because of sex. The federal government nor any state can discriminate against people on the basis of sex. And then the next one says that it now I'm getting the third one is the one where it gives us the 2 years. So the second one, I can't remember what the second one is. Wendy, are you there? Pop on. What's the second one? Are you there, Wendy? Gina? Somebody? Jean? Okay. Anyway, the second one has another clause. It's not about the deadline. But the third one says that the amendment becomes legally effective. Okay. Remember I said it became an amendment the minute it is finally ratified? Well, there was another compromise when they did it, and it said the third section says that it becomes legally effective 2 years after the date it is ratified. So basically, what they did is they gave 2 years to states and the federal government to get their act together, fix their laws before they started getting sued for violating the ERA. So the date that the ERA became legally effective was January 27th, 2022. Now, the Dobbs case was going on then. And the Dobbs case, there was a clinic that sued to be able to have abortions after and did knock down, I think it was a 15-week law that said you can only get an abortion for 15 weeks. After you've been pregnant 15 weeks and then you were banned. So what happened is that the Center for Reproductive Rights, it's an international reproductive rights law firm that's nonprofit, and they represented this that clinic, and now they're representing the 2 groups of women in Texas. But they had their oral argument on December 1st of 2021. So it was about a month, almost 2 months before the ERA became legally effective. When Dobbs was going on, they did not argue the ERA at all. They did not say anything about the ERA, and there were tons of amicus briefs. And none of the amicus briefs said anything about the ERA, did not use the ERA as a basis when the ERA was legally, it was not legally effective, but it was legally an amendment. And in its own language, it said that it would be effective on this at the second year. And the second year was coming up on January 27th, 2022. So I didn't read the briefs for Dobbs until after I heard the oral argument. And you can hear them as they happen nowadays from the Supreme Court. And I heard the argument, and nothing was said about the ERA, and I was basically in shock. So I wrote to the attorneys for the Center for Reproductive Rights, and I said, I'm from North Carolina. I said, y'all need to include the ERA and argue that because it is these are textualists. The Supreme Court now is very conservative. The majority of it is very conservative, and textualism means they look at the actual words in the Constitution. Well, the ERA, based on the text, says you cannot discriminate against anybody on the basis of sex. And I will say this as an aside that pregnancy is a sex-based related trait, like having being able to be pregnant. And Alito, who did Dobbs, doesn't even think that it is a sex-based trait. They compared pregnant people to unpregnant people, and they said unpregnant people can be men or women. So it's not just sex-based. But really, if you remember Venn diagrams with the circles, if you look at it, nobody who's a biological man can get pregnant. Only biological women can be pregnant. And the circle of people who are pregnant are a circle within that circle of women. So they're solely consumed by women. And another way, and I ended up filing something with Gina Callias, my sister, in the Dobbs case later on because we couldn't get the Center for Reproductive Rights to do anything. But that it is men cannot get pregnant. And so we argued that it was a sex based trait and that men's sex based trait is the ability to emit sperm. And there were no laws in that state, in nowhere that I know of, that makes men have to get vasectomies when they like turn 12. And that this has always been my theory. They could have a law where boys get vasectomies at 12, and when they get married, then they can go show their marriage certificate to the doctor and get it undone. And before they get a divorce, they can go get it done again. That's my theory on that one. And, but they can't get pregnant if they're not biological women. So it is a sex based trait. And so the Center for Reproductive Rights hadn't argued that. And I wrote to them multiple times, and they did not, they did not even respond. And I have an ERA legal blog on my website, and my website is arlenerocky.com, my name.com. And also, if you go to my Twitter, it's listed in the Twitter, and it says it's equal rights for women with dashes in between it. And if you go to my website, it's on the menu. So the most recent blog post explains all of this stuff, so you can go and read it if you want. But so what happened is I started writing to them, and I also it got to the point where I couldn't get in touch with them. And I mean, I wrote to their whole board, I wrote to their executive director, I wrote to them multiple times. And then the Alito leak happened on May 2nd, and everybody was freaked out. And he told us he was overturning Roe versus Wade. Well, the reason why they were overturning Roe versus Wade, which was the whole problem, was that it wasn't based on the text of the Constitution. There was nothing in the text that said you have a right to get an abortion. And there wasn't even anything in there that they could read that said that there was a sex discrimination prohibition, the ERA. because it wasn't published. Okay. And on the meantime, lots of women who had been working on the ERA had been writing to Biden and the White House, and lawyers were speaking with the White House counsel, which is one of them was Jean, who's going to be speaking next, and another one who are both our co-chairs. Nicole Verassi Bates is the other one, and they had been speaking to the White House counsel since before Dobbs, and they couldn't get them to do anything to like get Biden to publish the ERA. So anyhow, we had figured out already that Biden had to publish the ERA, and the reason that he has a constitutional duty, and this is the most important thing, he has a constitutional duty to publish the ERA. And the reason is Article 2 tells the president what their duties are. And Article 2, Section 3 says that the president has to take care to faithfully enforce the laws. Okay. And that means that there is a law that Wendy told you about. It's 1 U.S. Code, Section 106B. And it's the one that says that the archivist shall publish forthwith, which means immediately, after they get notice that 3/4 of the states have ratified the amendment. So there's the law, and Biden has a constitutional duty to enforce the laws. And not only that, he's the boss basically of the archivist. Some people say the archivist is their own branch of government, but there's 3 branches of government, and the archivist is part of the executive branch. And so just like Trump could be impeached for not following the law to enforce things on January 6th, Biden actually could be impeached for not publishing the ERA. That's an impeachable act to not faithfully enforce the laws. And the thing is that the Republicans could have added that to their little impeachment thing they were doing, but they didn't, because we know they don't want the ERA either. So anyhow, after the Alito leak came out, I was trying to get the emails for people in the White House, like the White House counsel and all that. And it's like, how everybody has email codes, like basically it's the same pattern. I finally figured it out, but I didn't figure it out soon enough to when we filed our motion. So the other thing is that only a party can file a motion after oral argument to ask to tell the court about new law. And the ERA was new law because it just became legally effective in January of 2022. So that's why I was freaking out trying to get the Center for Reproductive Rights to go ahead and do that. And they wouldn't do it. And honestly, to me, that is legal malpractice. That was malpractice. There's just no other word for it, because they had a duty to do it. And they were the only ones that could have done it legally. So even though they were only ones that could do it legally, since they wouldn't respond, Gina and I had an organization that's the ERA organization in North Carolina. It's ERA NC Alliance, that asked us to write something asking to do an amicus brief. It was a motion for leave to file an amicus brief in the Supreme Court in the Dobbs case, and we were already both members of the court, thankfully. And so we filed this thing, but it never got actually filed. It wasn't accepted for filing because we didn't represent a party, and it just sat on the docket. But it did get officially served on the Solicitor General, who represents the government, and upon the opposing parties, and also upon the Center for Reproductive Rights, because they represented the clinic. And it sat there on the docket. So, and they got a copy of it in emails, and which is how you serve them, and also through the system, the e-filing system. So what happened is that on right around June 17th, before Dobbs came down, I found out the emails. Long story of how I figured it out, but I did it, and I figured it out, and I ended up writing a letter on June 17th to the White House counsel, and I copied about 6 or 7 people high up in the White House. And I copied 2 lawyers, the head lawyer and one of the other assistant lawyers, for the vice president, and I copied top people. And in fact, I copied Jennifer O'Malley Dillon, who is now apparently the campaign manager for Biden for this time around, and she was the campaign manager the last time around in 2020. But she's the campaign manager. And I wrote them all and I told them why Biden had a constitutional duty to do this. And that is I mean, that is clear cut that he has a constitutional duty to do it. And I also drafted an executive order. You know, he was going around, he's still going around saying, "Oh, I'm doing executive orders to help people with abortions." Well, that's BS. He could have done an executive order and he can make a phone call, which is what we're asking him to do now, is to pick up the phone, Joe. Make the call, Joe is the hashtag. Make the call, Joe. Um, to have him pick up the phone and call the archivist and tell the archivist to publish the ERA. And we now have our first woman archivist. And she's basically seems like she's afraid until Biden tells her what to do. She said she will follow the law if he tells her to do it, and he won't tell her to do it. And he has been gaslighting everybody, telling us that he thinks Congress has to do something. Congress does not have any job left. Congress's job was done when they sent it out to the states in 1973. They don't have another job to do. And now that we're in an election year, everybody's afraid because of Trump. And believe me, I'm not saying don't vote for Biden, but I'm saying I'm not campaigning for Biden. I am not going to do anything to help him unless he publishes the ERA. But Gina and I also wrote an article together that was in eWomen's News, and it's also republished on my blog, that said gratitude is stronger than fear. If you recall, his very first campaign video came out, and it said that you shouldn't have to fear that you're going to lose you're going to have less rights, not more rights. And I will also say that the ERA will fix equal pay. It will fix LGBT rights because there's already been other case law using that same language about on the basis of sex that has been done by the Supreme Court that says that shows that the ERA will cover LGBT rights. And I'll tell you right now, my legal opinion is that it does not mean that children will be able to get medical treatment of changing their organs and everything necessarily, because you got to balance parents' rights versus the children's rights. But when they're adults, they should be able to get their treatment. That's my opinion, basing having been a lawyer dealing with children my whole career. So anyway, I wrote to them on June 17th and I said, he needs to publish the ERA right now. Here is an executive order. And I think I told him in that one to go ahead and call and then make a big deal. And the other thing I said is people will love you. Okay. And this is a historic thing. Women are second class citizens legally in our country. We are second class citizens. There's no ifs, ands, or buts about it. This will be the second most historic act of any president ever. We had the Emancipation Proclamation, and that freed the slaves. This can be an equality proclamation. He can call it whatever he wants. But this is a historic act because he will be making women equal citizens legally for the first time in about 245 years, our whole entire history. That is a huge thing. And he will go down in history for that. And he should want to go down in history for that. He should get some cojones, okay, and do it. But he hasn't done it yet. And so he didn't do it. He knew because I wrote to so many people and I know they told him. They had to have told him. And I'm sure the vice president has known too. And I feel like since Dobbs, she has gone around like she has two hands tied behind her back, trying to do everything she can do for women, except say, we could fix this with one phone call when she knows that they can. And it pains me because I love her. But this is very, very disconcerting. So they didn't change it then, and he went ahead and used it for the midterms. He used the fear and the horrible stuff that happened with Dobbs for the midterms to try to get votes. And they did well in the midterms, Democrats did. I mean, I'm a Democrat. I've been a Democrat my whole life. They did well in the midterms. But then things started going really south because we know doctors have been losing their professions. They've had to move or stop practicing. People are dying. People are having to get sepsis before they can get, just because in the case that just happened this week, this says that hospitals have to provide care. There's a lot of hospitals won't touch those cases until they're literally on death's bed when they're supposed to stabilize them, do anything to stabilize them. And even when it's an abortion, they're supposed to stabilize the patients. And that's what that case was this past week. And so things are horrendous now. I mean, it's gotten so bad. I don't think any of us ever could have figured out thought of how bad it could get for women and their families. I mean, we've got the IVF problems, everything. Okay. So what we're trying to do with equal means equal, they've got a new campaign out, and it's called the Final Impact for the ERA, and it's Make the Call Joe. And they have a lot of artists, they have some other celebrities and stuff, and they're getting ready to try to do a multimedia campaign. They're going to do a media multi campaign. They're starting it. And so equal means equal. You should be following them on social media and republishing everything. But we have to use every way we can to tell Biden enough is enough. This is ridiculous. He has a duty, a moral duty, to publish the ERA to save people's lives and livelihoods.
Thank you.
And
Oh, go ahead.
mhm,
Are you all done, Arlene?
not quite.
Okay, go ahead.
Just a minute. Okay. So I've got a a, a petition on my website, on my blog, and on my social media. And I also have my other one I use a lot is ERA for repro rights. 4 is a number, ERA for repro rights. And on all social media, I use that or some other stuff. But equal means equal is equal means equal everywhere. And they're doing a lot on Twitter and a lot on Instagram. And we need to get this word out now, really, before the convention. We need to push for him to publish before the convention, because this is when it's important. And the young people need to know this. I mean, I've got granddaughters, I've got a daughter that are still of age. My granddaughters are young. I mean, this is affecting everybody. And there's not that many of us on here, but this has got to multiply and spread. So please do that, and please read my legal blog. And I would like to turn it over to Jean, because Jean is running the National ERA Publication Task Force, and we meet weekly. And we're always trying, we've got different things going on, trying to get the word out. And we really need to do this, because Biden is making everyone think there's nothing he can do, and it's a lie. And if you read my blog post, I give examples of women who are in these cases in Texas, where he's been having them do commercials for him. He went to twice, he and then his wife went the next time to the human rights campaigns dinners and functions, and saying, we've got your backs. He doesn't have our backs. That's BS. He is lying to us and gaslighting, and that is outrageous. It's outrageous. And people need to know that. And he can fix this with one phone call. Thank you. I'll hush. I appreciate y'all.
Thank you, Arlene. I just wanted to say, if anyone has questions after Jean, we can just, you know, ask any questions. I have a ton myself, but go ahead, Jean.
Um, well, thank you so much, Wendy, and thank you so much, Arlene. Um, there's tons of moving pieces to all of this, but I think you've gotten a really good overview of the legal issues. On the political side, there's just lots going on. The bottom line is that we need to put enough political pressure on Biden to publish the Equal Rights Amendment. And the only way to do that is to use leverage And really, as Wendy said, the only real leverage we have is to say to him, unless you publish the Equal Rights Amendment, we're not inclined to get out and vote. So the question is, how do you relay that to him? So there's a couple of things that everyone can kind of do. Um, Arlene has her website, which is arlenerocky.com. Um, I have published the ERA.com, which will take you to shatteringglass.org. And on that website, there's a whole action page for everybody. One of the easy things you can do is to text the White House comment line, and Vice President Harris has a new comment line. So the White House comment line is 302 And if you have a morning ritual, you can get up in the morning and just text him, say, publish the ERA, Joe. And Harris's comment line is 310-861-2977. So those are two real simple actions you can do. There is a lot of work that's going on in the Congress to signal to Biden to publish. There's a lot of debate about there actually is no congressional role, but the idea is that Congress can signal to Biden and in concept signal to the Supreme Court that they're behind the Equal Rights Amendment. Um, and so people are going in and trying to get co-sponsors for two sets of bills, and I'll just tell you really quickly what they are. HJ Res 82 and SJ Res 39. Those bills are written to the Archivist of the United States, calling on the Archivist to publish. And that is under Cori Bush in the House and Senator Gillibrand in the Senate. And then there's bills that are kind of bouncing around that are a little bit more controversial, and that's SJ Res 4 and HJ Res 25. SJ Res 4 is just saying the Equal Rights Amendment is valid, and HJ Res 25 is the same. It says that it's valid. Our publication team is working on HJ Res 82 and SJ Res 39. Um, as Arlene was talking, we were at the White House very clearly before the Dobbs decision uh, at White House Counsel and saying you have to have Biden publish this Equal Rights Amendment. This is really dangerous. And so the White House basically rolled the dice, and that's what they basically said said to us. They were just going to roll the dice. Um, and we are working on the political piece because this really at this point is just political pressure on Biden. I do believe that if Schumer picks the phone up and says to Biden, you've got to publish, Joe, that it's a done deal. And then the question, as Arlene was saying, is how do we go to Biden and say to him, if you publish, the women's vote will come at you. They're saying, they're trying to get the women's vote on reproductive rights. Um, and the feeling is a lot of people are kind of tired of it and may just kind of that I don't think that's driving people to the polls. But we really need to convince Biden and the White House that if they want to win, they have to publish the Equal Rights Amendment. And the more education that people have and the more voices we have there, the more leverage we can put on them. So why don't I have Katrina open it up for questions and we'll take it from there.
Okay, thank you to all the speakers for all the education that you're providing us. Can you hear me, by the way? My
Yes,
mute
yes.
thing. Okay, okay. Yeah, it was showing that I was still muted. So yeah, we can just open it up for questions. I mean, I have plenty, but I'll just start out, and then if anyone has questions, just request to become a speaker, and then we can take your question. But so what was my question? I mean, I have so many. Well, I guess the main point right now is you're just trying to get Biden to publish it because, you've done all the work. I just kind of have, uh, questions about. I guess I'm kind of backtracking because 'cause I'm kind of curious, like, when Wendy was talking about some of these anti-ERA states, I was just kind of curious why they're anti-ERA, and I don't mean to kind of swerve off of the action step of, getting Joe Biden to actually publish this, but I'm kinda curious if you can just talk about that just a little bit, and then, we'll get back on track.
Can I just say that really quickly? What she was talking about is there were 5 states that tried to rescind their ratifications, okay? And one of the things that article from the Chicago Bar did, she went through and she used Scalia's textualist and originalist methodology, which is a very conservative methodology, which is what the Supreme Court uses. And what she found and says in there, and it's linked in my that is linked prominently in my blog, so you can read it. But what it basically is like is if you're having someone make a contract for you. So like basically what it is that your representative in Congress sends out a if you have someone make a contract for you and they're not the principal to the contract, they're like your agent, right? And the principal, say it was a company or something, the principal would have to vote to ratify the contract. And that's what ratification is. So their agent is their representative, and the state, when they ratify, they're ratifying that contract. You can't take it back. It's a one-way street. And that's what happened. You can't, that's the law. You cannot, ratifications are, I mean, rescissions, you can't rescind the ratification. So it's just one-way street. It's done, and they can't take it back, even if it was done 50 years ago.
Arlene,
Yeah.
I think her question is more political. We're not debating, and I don't think anybody really believes that you can rescind a ratification. But I think if Katrina's question is why would any state be opposed, I think the number now is 11 states that have not ratified, and I'm not going to include the 5 that tried to rescind. But among the 11 that have not ratified, if you ask them directly what it is about the ERA that makes them not support women's equality, they'll hem and haw about things that are irrational, but that don't even they don't even come to the top at this point like they did 30, 40 years ago when there were opponents to the ERA in the 70s. They were saying things like, we don't want men in women's bathrooms, we don't want women fighting in war, um, women won't be able to get support when they get divorced. These were all these scare tactics, and those all, have kind of come and gone. So the arguments that might have been palatable back then aren't even made today because they just don't ring true anymore. So the answer to the question, why would you be opposed to the ERA today, is they don't actually say very much. They don't say anything. What they might say is, we couldn't then have protectionist legislation. For example, you couldn't have special protections for women. I'm trying to think of where there's a good protectionist argument. Oh, let's say you couldn't have uh, uh, what do you call them, preferences for women businesses when they're trying to get loans, or when there are municipalities trying to start businesses, support businesses, they can't favor minority owned or women owned businesses, and women won't be able to have protection from sexual harassment. There's a lot of protectionist talk in this, but I want to be very, very clear. That's cover for the real agenda. The real agenda is, there's an enormous amount of money being made from women's inequality, corporate money. Corporations have always opposed the ERA, always. And the corporations oppose women's equality for a lot of reasons, not least of which is, well, then they'd have to pay them more money. and they don't want to do that. And even with equal pay laws, they can pay them less, so they're okay with current equal pay laws. But beyond that, there's literally trillions of dollars being made from porn and sex trafficking that the profits for which would suffer. Now, this is all dark money stuff, so it's not, no one's going to say this out loud, but the porn industry, the sex trafficking industry, they often lobby as big tech. They have complete control over all branches of government. I shouldn't say complete, but they have a lot of influence over all branches of government. Uh, and they lobby like nobody's business in Washington because I think they're the number two lobbyist. Big tech, to the extent they make enormous amounts of money on pornography, is going to be your number one opponent to women's equality, because if women had equality, much of what sells in porn would become illegal, because because you couldn't do that to a fully equal person. You can't do that to an equal person. You can do it to someone whose rights are not equally protected, because they're not entitled to equal protection of rape laws, for example. They're not entitled to equal protection of sex trafficking laws. Hell, women aren't even entitled to equal protection of laws against slavery. So, so the real reason there's opposition, and this includes opposition from both parties, and it includes opposition that's a little bit more veiled in states that have already ratified. They're opposed because it would cost enormous amounts of money in profits to those big industries, especially porn and sex trafficking. And no one's ever going to say that out loud. So they come up with these pretextual reasons. Well, then women, will have to go into the same locker room with men. That's not true. And just I want to be clear about this, because this does come up. Um, if it were true that having equal rights under the law meant you can never have differentness in the law. That's really the argument, that there can never be any differences. There can be differences. Even under the ERA, there can be differences, and you can have different treatment of women, but you have to show three things to do it. You have to have the government has to show that it has a compelling need to do the different treatment, that it has narrowly tailored the provision, the rule, or the law so that it serves that compelling interest. And they have to use the least restrictive means to achieve the goal. So it's still doable. You can still, it's sort of like in Title VII law, when employers want to discriminate against a person based on sex, and you go apply to Hooters. Well, Hooters only hires waitresses with big boobs, or with boobs anyway. I don't know how big they have to be. So is that discriminatory? Yes. But is it allowed? Yes, because it's considered a bona fide occupation requirement. Same is true if you want to hire a black person to appear in a movie where you need a black witness, a black character to play the scene. Is it discrimination if you hire a black person and not an Asian person? Well, yes, but it's requirement, right? So there are lots of examples where, even with the ERA in place, as we have equality laws in place for other categories of people, when you need to discriminate, as long as you can justify it and demonstrate that it supports a compelling state interest, you can do it. And I'll just make this point to be, sort of super clear about the fear mongering that sometimes goes on in other organizations that say, oh, these are sometimes women's groups who say, we don't want the ERA because um, it's going to mean that, men can run on women's track teams, for example, that it's going to permit um, permit everybody to compete regardless of skill. And it will disallow colleges to take the history of women's subjugation into account when they admit you as a student. Same goes for race. Just know this: the way the law works now, you don't have to have a compelling need for anything. You can discriminate widely and based on sex, and all branches of government just roll their eyes at the idea that you can't discriminate against women because they know that you can. They don't feel that way on issues of race, national origin, and religion, because those categories are at the top of the heap when it comes to the legal standards, the judicial review standards that protect against discrimination in those categories. They're very, very strict. They're not very strict for women. So some people are saying, well, if you get women up to that strict category, then men are going to get to do everything women do, and it's going to be terrible. And women are, men are going to be in women's bathrooms all the time, raping them and so forth. But the reality is, and you're not going to have any of these special preferences, especially like consideration for Title IX sports, consideration for safety and whatever, and even rules around pregnancy and reproduction. You're just never going to have any kind of consideration for your status as a woman. The reason this is not true is that because, for example, the category of race has the highest level of legal protection, which is where women want to be, where you have to have strict scrutiny, a compelling need, and all of that stuff that I mentioned. If it were true that you could have better affirmative action policies and better racial preferences in employment and so forth under those weaker standards, the Black community would be begging for inequality alongside the status that women now have. I mean, that's the best argument we can make. If it were better to be second class, because if you give the government space to discriminate, they can discriminate in a positive way for you, the Black community would beg for that second class status because they would want the government to be doing all of this favorable discriminating. But the reality is, the category of Black, the Black community in this country is at the top tier of protection against race discrimination. They get maximum legal protection against race discrimination, much better protection than sex gets as a category. And no one is complaining. No one is complaining that they now cannot get affirmative action. They cannot get racial preferences in hiring and so forth. They can. They absolutely can, and they do. And if it were not the case, they would be asking to weaken their rights to open up that space for that kind of so-called positive discrimination. And it's just not happening. There's some fear mongering going on about that, which is why I mentioned it. And some of the women's groups that are arguing in favor of keeping women second-class citizens and arguing against the ERA, some of them are saying, you should be opposed to feminism and opposed to this form of feminism that wants the ERA because it's going to hurt you for these reasons that I just described. But they're really they're covering their actual agenda, and they're also not telling the truth about their funding. A lot of those groups are funded by religious organizations. They're deeply anti-women's equality for all the same reasons everybody else is, that they're funded by sources that make enormous amounts of money keeping women down, keeping them subjugated, keeping them rapeable, keeping them pornified. The true feminists have always said equality is the great liberation, and it's the great liberation because it, across the board, stops the government from treating you differently and worse simply because you're female. Across the board, it stops the government from treating you differently and worse simply because you're female. You cannot make an argument that inequality is good for women. Even, the most brilliant scholars that have tried to come up with a good reason why we should not have the ERA in a way that's good for women, there's nothing. And it's so absurd. It really is a sort of bizarre moment in time for women, because we actually have women calling themselves feminists arguing against equality for women. And that is a challenging place for us to be, but it is happening right now. So I just wanted to make that point clear, because you ask, why are states opposed? The answer is money. The answer is always money. Why are people opposed to something or in favor of something? It's always about money. People don't talk about the moneyed interests in terms of who's opposing the ERA and why, because it's dark money. It's deep dark money, and it's money that funds both parties, like a lot of other deep dark monies do. So this is why it's not a partisan issue, never has been. Women have been batted back and forth like ping pong balls, as if we should, you know, aligned like lemmings behind the Democrats. Oh, but 50 years ago we were aligned like lemmings behind the Republicans, and then 50 years from now we'll be back aligned again. No, we are not ping pong balls to be batted back and forth between two parties, neither of whom has an interest in actually elevating us out of our subjugation. Both make enormous amounts of money, keeping us right where we are. And it is time we remembered what Alice Paul did, because that's why she was so successful. Being nonpartisan is vital, vital to success. Alice knew it. She's she was brilliant. She was marginalized for being brilliant because she knew the importance of being nonpartisan. And we've reached the stage now where it's time to bring Alice back. So we need an Alice. If there's anybody in this group that wants to step up and be our next Alice, I'll work for you for free. But we gotta find a leader. Maybe it's you, Katrina. Katrina Alice. Can you change your name to Alice?
Haha, very funny. So it looks like Patsy wants to ask a question, and while we're situating that, I wanted to ask, so is Joe Biden not publishing this just because of like, what is his argument? Is it just the whole, time period thing,
No,
or is
Yeah.
I'll
there
tell you,
something?
he is deflecting and lying and saying that he thinks Congress has to do something. That's his thing. He keeps putting out things saying that if Congress passes a resolution, he will agree to it. That is just BS. It's a lie. He
He
has
knows,
literally been lying.
Joe Biden knows that Congress has no role to play at this point, which makes Congress the convenient excuse for him to do nothing. He says, I support the ERA and I'm just waiting for Congress. The rest of us rolled our eyes when he said that. And, like, you Congress has nothing to do right now on the ERA, nothing. Now, they've tried repeatedly to come up with something. Oh, we're going to pass a law removing the deadline. Nope, you can't do that. Oh, we're going to pass a law validating the ERA. Can't do that either. They fancy themselves in charge of everything when it comes to this issue. Oh, we can pass a law saying this, that, and the other thing. No, it's like Biden promising to codify Roe versus Wade. Congress doesn't have the power to codify Roe versus Wade. Even if every single member of Congress was pro Roe versus Wade, they still don't have authority. They don't have any constitutional authority to codify Roe versus Wade. And it doesn't matter. The Democrats
With
are promising, if you just vote for Democrats, we'll codify Roe versus Wade. It's just
Okay,
an
okay,
outright lie.
Wendy,
Yeah.
the reason they don't have the power is because he has to publish the ERA first. The ERA is the textual basis to codify Roe.
We
That's
don't
what the
need we
other,
won't
remember,
need we
listen,
won't
listen.
need Congress to codify Roe with the
I
ERA.
know we won't, but listen, the part that I couldn't remember, the second part is that Congress can make any laws to further effectuate the ERA. They can make any laws based on the ERA.
That's where, and the 14th
And
Amendment
that's it.
is what gave Congress the power to pass civil rights laws where women got
Right.
the shitty
Right.
Title IX thing. No,
Okay. Let's
it's a,
hush. We got other questions. I just wanted to say that's what
Okay,
I
good.
remembered.
Okay. Patsy Mink, I've been trying to add you as a speaker so you can ask your
I
question.
I'm here. Can you hear me?
Oh, you're here? Okay, okay, yeah, go ahead then.
Yeah, no, you did already. So listen, this is an amazing space. I wish more people were here, but we're just gonna have to get people to listen to the recording. I mean, my brain is on fire. I've got so many questions, but I just have one really major one, and it's back to Biden and his refusal to step out with this. And I'm thinking that it could help with sort of a bipartisan approach, because my gut feeling is the reason he's not doing it is because he's enthralled to the gender lobby. I mean, if you look at the new Title IX regulations, I mean, it's obvious that they're replacing sex, biology, women as a biological reality with gender identity, which ironically lets all the men into the women's bathrooms. So, for me, a way to reach out, across the aisle is women all over the country from both parties who want to retain their rights and their in language and in law as women, as female, as a biological reality. um I guess I don't know, what the Constitution would say about that. I mean, the Constitution has a lot to say about men and who and what men are. So would this give women the a standing in law? I think it would, but I mean, I'm not a lawyer.
I'll say, let me
As a
respond very
biological
quickly.
reality, and then that would sort of create this standard that women are they we exist, we're real, we have rights, and we have we have a place in the scheme of
You're,
things. So
you're,
I'll
no,
shut up
no, you're
and let.
right. And I hope you have lots of other questions related to this because it's really important. You're talking about a category of activism fairly robust in the recent past, but has been around for a while about what to do with trans people in general, but specifically with regard to attempts to redefine the word sex to cover some amorphous concept. And here's the thing. I don't want to get too complicated here, but there's a lot more to your question than we can probably cover tonight. What I do want to say is, um, the way the leading case that answered the question, do women deserve the same high degree of judicial scrutiny as Black people, which I'm going way back to the 70s, right? The leading case said at that time, this is the one I told you was later overturned. Um, so it's important to remember the Frontero case from when I was talking before, which said women are exactly the same level as race. Sex and race are the same. They both deserve maximum legal protection. That was in Frontero in 1973, and then the Supreme Court took that away after the ERA was considered over. And when they took it away, they bumped us down to this place where we are now, this second class crappy place. But what's important is in that 73 case in Frontero, when the court said sex and race are the same, they said because they're both immutable characteristics. Immutable meaning you cannot change them. They come at birth and they don't change. So this is beautiful language on your point, right? That sex is immutable. You cannot change it. You can change your clothes. You can even change your body parts. You cannot change sex. You can even change gender because gender is not the same as sex. Gender is a construct. It's not a biology. It's how you feel. It's a way of categorizing aspects of how people function in society. Fine. You call yourself anything you want, but sex is sex. So the word sex in the ERA does help to firm up the existence of femaleness as an immutable class of people, period. However, this is a big fat however, the nature of this transgender movement in terms of the radicalization of the term, and I don't mean transgender people, I mean the politicians who are exploiting it. Because I know transgender people, they don't even agree with what the politicians are saying. This notion that if you are born female, you can become male as a sex. Most transgender people don't agree with that. They don't. But the reason politicians are jumping on the bandwagon is because in the event the ERA ever does become valid, what a brilliant argument that can be made now to still treat women like shit. If we become fully equal because the ERA gets passed, right? And then somebody goes to court and says, well, how are we going to apply the ERA? There's going to be an argument. Well, there was a time when you had to treat sex and race the same at that very high level because they're both immutable. We now know that sex is mutable, that you can change sex, that it's not something you're born with and that doesn't change. So I'm concerned about that. But what I want to say that's even more important, because I do think dividing women and hurting women and making them fight is intentional in terms of what this gender stuff is right now. I think it's intended to make women divide and fight. And I try really hard not to indulge it, except to make occasional comments about how sex is real. And I feel very strongly about that. Female is a category. And the most important reason for having femaleness as a category is political, not biological. I mean, but the biological is the political, right? The reason women are subjugated is because of their biology. So you can't really separate them. But what I'm saying is we need the political cohesion of sex as an identifiable class in order to have the power, strength, and staying power in particular that we need to forge a movement. If we become an amorphous class where you can be a woman today and maybe not tomorrow, we have just lost our political heft. We've lost our political strength. We've lost our political existence. We don't exist as a stable political class. That is the reason why this gender stuff is as intense as it is right now. It's not coming from the sincere trans people. It's coming from a group of very moneyed interests who are exploiting trans people to divide women and to make sure that women never achieve that unity that I'm talking about. It's a brilliant maneuver when you think about it, but I'm very nervous about it because, I mean, I don't mind speaking up, but there are people who are very anxious about speaking up against anything but even if you say, well, no, I favor the existence of women as a sex class, you get your head bit off. You can get in trouble for that. So women getting in trouble for describing themselves as existing as a sex class is a problem, but it's all the more reason to push for the ERA. Now, the only thing I'm going to say about, well, why don't we make it bipartisan and go to Biden and talk about how wonderful this would be? No, Biden is as on board as any Republican with keeping women down, keeping women non political, making sure they don't have power. This is because it's about money. It's not about party. Neither party wants women to have equality. So we can't think about this as a partisan issue, a bipartisan issue, this partisan. No, it's about money. And we will never have the money we need to fight back against the anti ERA money. We will never have it, ever, 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 ever. What we do have is leverage in our votes. We are 170 million women strong. We have votes. We don't have money, but we have votes. And if we can leverage them, we can be even more powerful than money, but only at certain times, like right now, because the presidential election is before us. This moment in time is when we have power. We'll never have money. We'll rarely have this kind of power, especially in terms of the timeliness of this ERA issue. So it's now or never. If we don't get this done by November, and if we don't do it in a nonpartisan way that threatens Biden that he will lose and threatens the Democrats that they will lose and that we will vote for independence. I mean, if that and this is, I think, speaks to the importance of somebody like Katrina even being out there. Katrina is going to be the attractive candidate because she's not the two moneyed parties who hate women's equality. I mean, we are going to vote for Katrina all the time. Why? Because she's not under the influence of those dollars. It's really that simple. It's that simple. Anyway, go ahead, Patsy.
I'm so sorry, just super quick. If anybody else wants to request to speak, has a question for Arlene, Wendy, or Gina. I know Carissa had requested to speak earlier and it actually didn't work. So if she still wanted to speak, if another co-host could please approve and maybe it won't kick her out like it did last time. Sorry to interrupt. Go ahead, Patsy.
So I have another question. You were speaking earlier, I think Arlene was, and it was so dense. I mean, I'm going to have to re-listen to the space and take notes, but it's really rich and wonderful. But you were talking about a decision in the I think it was the early 70s. No, 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 it couldn't have been. It was a decision that it was either Scalia or Alito had defined women as not men. Did I hear something wrong?
Are you talking about the
And
Bostock case for the trans people?
yes,
Yeah,
yes,
okay. So what you ought to do is
and
read you're really
clarify that
go ahead.
I'm shocked that that came out of that right wing end of the court.
Yeah, it
So
did. It
could
came out it was Kennedy, wasn't it? I think, y'all. Um, the thing is that you ought to read the Bostock case because it doesn't really have to do with trans people being transgendered so much as it's
no,
more
it's
like
just the
gay.
point.
It's more like people having it's more like people having um it was more like a thing of almost like a gay marriage kind of thing, like two gay people. And he wasn't even really talking about trans, but I do want to say that, so far we can't change our genetic code. And the reason I don't think it's such a problem is because of the way the Bostock case came out, how it was reasoned. It was a really bizarre reasoning, so you'd have to read it. But it's Bostock, and you can just Google it and read
Bostock
it.
Bostock was
What
only a
B
Bostock was only a few years ago. It did involve
Right.
only transgender people, but the court's attention was really on whether the word sex under Title VII covers trans people. And the court said, yes, it does, just like we've already ruled many times that it covers gay people. The word sex, they decided, is broad enough to capture all categories that have to do with um, sex-based ideas, and that could be that could include how you dress. It could include because that also covers women. Like a woman, if a
Mhm.
woman is discriminated against because she's wearing a certain outfit, that's a form of sex discrimination. So the court was sort of saying, why wouldn't that approach to the concept of sex discrimination cover all people if it's about what they're wearing? It wasn't that big a deal, but they did leave some wiggle room, in my opinion, for the possibility that they will one day in the future embrace this notion that there's fluidity in sex. They didn't say it, but there was a little bit too much enthusiasm. The court was a little, especially the conservatives, the look, conservatives don't give a shit about transgender people. Neither do the Democrats. They don't give a shit about these people. They care about using these people to exploit other agendas. And in particular, they want to exploit the trans community, this tiny, minuscule community, to undermine the women's movement. And to me, that's what's really going on here. And that's why they reached down and took that Title VII case up to do the. I filed a brief in the Bostock case, and I said all people should be treated equally. I don't have any problem with anyone being treated equally. Like we should all support. Now, I want to be clear. I want you to know this. This is really important. I wrote an amicus brief. I supported the trans people. And what I said was, yes, they should have equality too. Everybody should be treated equally under the law. This was my brief. Okay. Now, as soon as the case came down, I was in the middle of working on these ERA cases at the same time. So as soon as the decision came down, and I was on an amicus brief list of lawyers, so many amicus briefs were filed in Bostock, and they were almost invariably favorable to the concept of treating Title VII as broad enough. The word sex is broad enough to cover trans people. So, we were all sort of on the same side. We may have written differently in our briefs, but my brief was basically, if you treat people unequally, they suffer harm, and we don't want to do that. Like, I mean, it was really very straightforward. So when it was done, we all sent a celebratory series of emails to each other in this really long list. There were probably 75 um, lawyers on this list. Many were scholars, academics. Larry Tribe was on there. People from, law schools of great repute. And everyone was saying, good job, good job, good job. And then I wrote to all of them at the same time, 75 lawyers, many constitutional scholars from the best law schools in the country. And I said, now that we have a case that has decided that sex covers all categories, how about you all file amicus briefs in my case? Because I'm trying to get the ERA in the Constitution, and the ERA uses the word sex. So if you all file amicus briefs in my lawsuit, you will be supporting the improvement of Bostock, never mind Title VII, which is just an employment discrimination law, you will bump trans people right up to constitutional protection, which is way better than Title VII. That's a much broader grant of equality, right? You don't just want equality for trans people in their jobs. Don't you want equality for trans people in everything they do? And I sent this little email along saying, surely you now want to support the ERA, right? Because the ERA uses the word sex, as does Title VII. So surely you want to help us, right? You know what I heard back? Crickets. Not one person offered to help. Not one of them supports the ERA. Not one. What does that tell you? What does that tell you?
Hey, Wendy, I want to say one other thing to y'all. One of the things Dobbs did is it put question marks around what we call substantive due process. And that is a really horrible thing because what's happening is we're not only, I mean, they're not done taking away our rights, okay? They're going to go after contraception and they're going to go after gay marriage. And that is, I mean, for sure, they're going after gay marriage. And I actually wrote another letter to Biden in the White House right before the fourth anniversary of the ERA. And one of the things my last blog post is that letter. Okay, and it's embellished with like video and pictures and whatever. But one of the things I put in there is what is Pete Buttigieg gonna think when his marriage gets dissolved? Biden actually says, "Oh, he's like my son." Well, he's not even thinking of people he cares about.
Arlene, gay marriage is not going anywhere. All due respect, there's a lot of money behind gay marriage, and they're never going to touch it. And all the conservatives support gay marriage. I understand what you're saying, but that's not going to happen. They care about money. They don't care about due process or ideology. They care about money, 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 money,
Well, I
and
don't know that the Supreme Court cares about
they.
that.
That's all they care about.
If we don't have the ERA, it's up for grabs,
Yeah, the Supreme
honestly.
Court cares about money. Every branch of government cares about money. And we have to just get our heads around that. This is about money. They don't care about ideology.
I'm gonna let somebody else ask a question
They
then.
would rule in favor of the devil incarnate if it meant money. And they would rule
Well,
against the
they
devil.
they they already are doing that, Wendy.
I'm
But
just let's stay focused because if it's about money, then we're not here to talk ideology. We're here to talk about getting the ERA and the Constitution, and it's a money problem for this country. It's money.
okay, so, Dark Violet made a comment, she wrote it, and she basically doesn't have any confidence that the Democrats or Biden will pass the ERA, and I have to say, I feel the same exact way. I was listening to Jean and Arlene, saying, "Okay, let's text them every day, let's get involved with Equal Means Equal." And, I'm willing to do some of that, but just don't feel confident in this strategy. So I'm just kind of curious what you guys have to say about that because I mean,
I hear you. I hear you, Katrina. But you know what? What else do we have except our threat not to vote? That's our only thing we have. We don't have anything else. If I could, I would fly airplanes over the White House every day. I would put billboards up all over the place. I would, I don't know what else we can do except
I do. I think we need to get it out. We've been trying to get this into mainstream media that he could have stopped Dobbs. He's going around saying that Trump is the reason we don't have rights, repro rights. Okay, and that's a lie. I think the truth needs to be out there that he knew that he could have stopped Dobbs and he
the
didn't.
media are controlled by the same money that we're talking about. The media,
Okay, well,
oh,
she asked, what can we do? We have to get it out there. It's
yeah,
not
but it's
even
not going to.
in
We're not
social
going to get it out.
media.
The media.
It's not even in social media.
Well, that
Okay?
that that I agree with. So getting it out, right? We need to organize external to the moneyed influences. Agree.
Okay. Well, we have to get it made known. People don't understand what he did
It's not. It's not as relevant.
and how he's lying.
The
I think it is relevant that
no
he's
no
lying.
reason it's not relevant to spend a lot of energy talking about how Biden caused Dobbs is because of Alito saying in Dobbs, this is not a sex-based issue. Do- Dobbs says that. Dobbs says
I
this is
know
not,
they say that, but that doesn't mean that's accurate
I
because there
know, but
is no ERA.
you can't take on an
They
added,
didn't use the ERA.
I know that, but you cannot take on an added issue. We're just trying to get publication. So let's just
I'm
focus.
trying to get what about the fact that he has a legal duty, a constitutional
Right.
duty to publish
Yeah,
it?
I agree with that, but
Okay, well
we have to
the country
focus.
doesn't know that.
The country
The
does.
country doesn't know that
Well,
he
that
knows
well,
that.
I guess that's what we're doing here. I mean, there's only 18 of us here, but at least, we're a tiny portion of the country, and I guess it's really our duties to start amplifying this. And, I
But I
just
think if we follow kind of the success that Alice Paul had with the 19th Amendment, which is basically to stay nonpartisan and focused on exactly what we want, which is
Yep,
publication of the Equal Rights
yep.
Amendment. I mean, we've added the Equal Rights Amendment to the Constitution of the United States. I mean, Alice Paul was working to get the 19th Amendment added to the Constitution, and they were able to do that. But we've already done that. We've done that. We did that January 27th of
Good point.
2020.
And
Good.
we need the publication so the courts are on notice and they can't ignore it
Yeah, no, I
anymore.
think what she's saying is it's a small ask compared to what Alice had to go through. This is a small ask. Just getting him to pick up that phone. Biden is not in good shape in some of the swing states. He's not in good shape. So we could choose to focus our energy in the swing states and just not, instead of nationally just swinging at balls all day long, we could focus on the swing states. What I think is true, and I don't know this because this is not my field, but I think he's got a couple of states that he's very worried about where RFK Jr. is doing well enough to really hurt his chances of making it in those particular states. Maybe what we should do is track where RFK is doing well and focus our energies in those states because we don't have the resources to win the whole country. We don't even have the resources to win all the swing states. What we do potentially have the resources to do is to target our resources on a state that could turn the election. And whatever that state is, if we really focus, we might be able to capture the imagination of enough independents to get it up to a point where Biden cares. Biden needs to care. He needs to think that there's significance to what we're saying. Right now, he doesn't give a shit.
so it looks like Patsy wants to ask
Well,
a
there's no leverage
oh,
on him. I mean, if
I
you
just
watch this,
I have a
what
quick comment to follow up on the RFK idea. Um, it's how about pressuring RFK to commit to ratifying the ERA?
I've done that. I've done that, and I've spoken directly with his people. It's funny you should say that. So, a friend of mine was on his podcast or whatever he calls his show that he does not long ago, and so she had a straight line to him. She not only introduced me, she shared my materials because I've written briefs on all these issues. I've briefed and briefed and briefed for a long time, all these issues. She sent him materials. She sent him my TED Talk. She sent him everything. And she said every time she's ever reached out to them on anything, they get back to her instantly. And on this, nothing, not a word. And he never mentions it. He never talks about women's rights uh, when. But remember, let me say this: his wife, Cheryl. I'm sorry, not his wife. His running mate, whatever her name is, the new woman running mate. She's got billions and billions of dollars from tech. So she's a tech CEO, whatever. She's got lots of money from tech. The tech industry, if the tech industry is funding his campaign, he'll never do it because that's porn. That's sex trafficking. They will never, ever let him speak about the ERA. They will stop funding him.
oh, sorry, I wanted to speak, but I was trying to work out a tech thing. So, Carissa, are you wanting to speak? I'll put a
But to your
oh,
point, Wendy, that we have limited resources. We
Carissa.
have, and we, again, going back to the brilliance of Alice Paul and the brilliance of the 19th Amendment, and knowing history repeats itself, and knowing that we've already gotten the ERA ratified and we just need it published. To your point, is how do we laser focus on one of these swing states so that Biden has to pay attention to us. He has to stand up. And we have to say to him, if you publish the Equal Rights Amendment, we'll go out and turn the women's vote in this particular state, if that's Arizona or whatever swing state it is. But they're, we don't have any leverage on them.
No, but I think, this is the whole point, is because we don't have a lot of resources, and because swing states in an electoral college system, the swing states are so vital, we can probably pretty easily find out where the state is that's both very important to Biden because RFK is close to it, doing well. I think RFK has 23 points in is it Michigan? He's got a big number in one of the swing states. If we can focus our energy on that state where at the margin it looks like our influence matters, that might make him pay attention. And I think we can do that.
So if it is Michigan,
Okay, let's take that offline.
if it I'm gonna
And the only other thing
I
is,
okay.
I just think, to Patsy's point, um, they're, the what they're trying to do, at least in Title IX, is this conflation of gender identity, um, and that's very different than kind of trans. So the Bostock is dealing with trans, but not necessarily dealing with gender identity. But Title IX is dealing with gender identity.
Well, the Title IX issue, the simple answer is if the ERA is in the Constitution, then Title IX cannot be treated like shit the way it's being treated right now, but it can be treated like shit without the ERA because it's considered a weaker, not as powerful civil rights law as Title VI. And people, women need to understand that. Title VI is supposed to be the same as Title IX. They're supposed to have the same power, same legal standards, same rights, and they don't. Women have much worse rights than the classes of people protected under Title VI because the ERA isn't in place. So anybody who cares about the Title IX issue should jump on board and help us. The problem is some of the people who are critical of the trans issue, some of the women's groups that are the leaders in the fight about the trans issue, and especially women in sports and all that, they are deeply conservative and not interested in the ERA. So they want Title IX to work better, but not, they don't want women to have equality under any laws. They just want, their this little law over here and that little law over there, but they don't really want women to have equality. And they're funded. A couple of those groups are funded by religious organizations. We have to be really careful just because they seem to be critical of what happened with Title IX last week. And I read the new regulations. There's 1,500 pages. I didn't read them all, but Title IX is one of my areas of expertise. I searched for the keywords that I was interested in, including this gender and sex stuff. They actually improved them a little bit, where they maintain sex as a category, unlike in the Equality Act, which is a proposed congressional bill. I don't know what its status is right now, but in the Equality Act, they were going to subsume sex within gender, and sex was really going to disappear as a subcategory. They did not do that in these new Title IX regs. They actually separate out sex, and there's a lot of language in there about women as a category separate from these other categories of trans or gender identity or whatever. Now, it's still problematic in the sense that there's some fluidity and overlap, but at least they don't erase sex. In the current regulations that just came out last week, they don't erase sex the way the Equality Act did.
Hey, really quick, sorry to interrupt. Carissa has been trying to speak for a while. So, Carissa, if you wanted to go ahead and say what you wanted to say, and then right after that, it'll be Patsy. Thank you.
Hey, hey everybody, thank you for having me. I would like to just, thank you for letting me be involved. I'm fairly new to politics because I'll be completely frank, I really didn't start giving a shit until Trump got elected. As far as I was concerned, it did not concern me, and I've come around to a different way of thinking at this point. So forgive me if sometimes I may not necessarily be very well educated. I'm still learning, and there's a lot listening to all of you. I've got a ways to go, but I will say this. I wanted to go back to the stuff about RFK, and um, I don't understand why supporting him or trying to get him in would be a good idea. The